So what I am going to talk to you about are the cleanup agreements that were signed in 2010 and December of 2010. And I just want to explain to you a couple of the key aspects of those agreements, because we're then going to have presentations by the agencies as to what progress they've made in carrying these out, and in fact whether there is any question about them fully complying with those agreements. Because as you now know, that contamination began almost 70 years ago, and we still have not embarked on the basic cleanup. There have been interim measures, but the basic cleanup, decades later, still hasn't started. This order, and a similar one with NASA, is supposed to get us towards that cleanup. So you see it's an administrative order for remedial action between Department of Energy and Department of Toxic Substances Control, and there's one almost identical with NASA. And for the DOE order, it covers all of Area 4 in the Northern Buffer Zone. That's the nuclear area and that area towards Brandeis, that some of which also got contaminated. So essentially the entire nuclear area, even if Boeing was responsible for some of it for non-DOE activities, the order has DOE cleaning it up. I'm trying to go quickly. It requires cleanup to background, and that we'll describe in a moment. And that permits what are called in situ or other on-site treatments of soil. That means you don't have to just take a shovel and dig it up and take it off. If you can treat it on site, there is a preference to do that. And that is not only allowed but encouraged in the AOC. The AOC, the cleanup agreement, covers soils, but look at the definition of soils. It covers both the saturated and unsaturated soil, the sediment, weathered bedrock, debris, structures, and other man-made materials, anthropogenic materials. So it covers not just what you think of as dirt, but it covers anything made by human beings, pipes, buildings, facilities. All are supposed to be cleaned up to background. And that's the key. The cleanup of soils at the site shall result in the end state after cleanup being consistent with background. At the completion of the cleanup, no contaminants shall remain in the soil above local background levels, with the exception of certain exemptions I'm going to describe in a moment. So what does that mean, cleanup to background? It means the commitment has been made, and in fact was initiated by the Department of Energy, by the Secretary, the then Secretary, and the then Assistant Secretary, that any contamination that they can detect, they will clean up. Background means what it was like, or what it would have been like if they never spilled anything. There's still contamination. You can't get away from it. That occurred not because of Santa Susana, and that doesn't have to get cleaned up. There's atmospheric fallout from nuclear weapons tests. There are natural materials, heavy metals, some natural radioactivity in soils and rock. That doesn't have to get cleaned up. You have to clean up the stuff you added to it by having partial meltdowns, by dumping the TCE directly into the ground. So it's a fancy way of saying what they contaminated, they will clean up if they can find it. Now, if it's at a level below a detection limit, they don't have to clean up below what they can detect. If it's below what's background, that was there without them messing it up, they don't have to clean it up. But if it's something they added by sloppy behavior, by accidents, by changing standards, and they can detect it, they are to clean it up. And this was a remarkable agreement initiated by Assistant Secretary of Energy Inez Triai, Dr. Triai, an expert on remediation, and by Dr. Stephen Chu, who was at that time the Secretary of Energy and a Nobel Prize winner in physics. So this was the offer, the proposal, the conclusion of the Department of Energy, and NASA agreed to a similar cleanup agreement. So let's go quickly to the core of that agreement, so that you can now be able to hear from the agencies as to how well they are carrying out the commitments that they made in it. So here are the core provisions. The end state will be background. and that's local background. You heard from EPA that they measured a few miles off the site to be able to find a place that wasn't, in their determination, affected by the facility. They determine what is background, they determine what's contaminated above background, and what's above background is supposed to get cleaned up. But there's flexibility built into the agreement. There are at least 3 exceptions. The first one is if there are any endangered or threatened species or critical habitat that the Fish and Wildlife Service says, no, we're not going to let you do something there. You may have to mitigate, you may not be permitted. But if they say there's a endangered species issue and you can't do it, then you can't do it. First exception. So anyone who is concerned that endangered species could be in trouble, the AOC has an exception. The cleanup agreement has an exception. The second exception is for detection limits. If you can't detect it, you don't have to clean it up. You only clean it up above the detection limit. The third, very important, Native American artifacts that are formally recognized as cultural resources. There is, for example, some remarkable cave paintings. Now, of course, no one did reactor work inside that cave, but if there were contamination there, it is exempted from the cleanup agreement. It is a recognized Native American artifact, so it is protected. And lastly, there is a kind of slush fund of exceptions for unforeseen circumstances. So if there's some reason, for some particular reason, that you shouldn't do a particular cleanup at a particular location, you can still get a flexibility. But they wrote in a 5% limit so that you can't use that exception to become the rule. So bottom line, clean up the background, but if there are endangered species, Native American artifacts, or other things we can't predict, there are exceptions built in. The other key part of the DoE order is that the U.S. Environmental Protection Agency will determine local background and detection limits. This was really important because it set up an independent entity. So it won't be the people who have to clean it up saying, hey, background's way up here. It was someone who didn't have vested interest in trying to avoid cleanup. And EPA, as you've heard, has done that study and has identified 500 locations with radioactive concentrations above background. And under this agreement, what they identify is supposed to then be cleaned up if it's over this lookup table, which is supposed to be essentially equivalent to background or detection limits. Another key part of the agreement is that it will be cleaned up to a not to exceed fashion. That means if it's above the cleanup limit, you'll clean it up. You can't average it with something somewhere else that's below the cleanup limit. If you have a backyard that's contaminated, you want it cleaned up. You don't want someone to say, I don't want to clean it up because there are 3 backyards a mile away that have lower concentrations. So if it's above it, you clean it up. You can't leave it in place. You have to actually clean it up. You can't just bury it on site. You have to actually remediate it. And then a very interesting one that we will hear about a little later, the disposal of the contaminated materials. Remember that soils include structures, debris. And that is that the soils, as broadly defined in the agreement, with radioactive contaminants above local background, must be disposed of in a licensed low-level radioactive waste site. That's because there's been a history at this site of radioactive waste being dumped in municipal landfills, Calabasas, Sunshine, and Bradley, radioactive metals being sent out for metal recycling, and this agreement bars that. EPA, as you see, is to do the following tasks, including conducting post-cleanup confirmatory radiation assessments, and is responsible for the investigation of radioactive contamination. DTSC is responsible for determining background and chemical contamination on site. So the agreement at its core is pretty simple. If they messed up that site and they can locate where they messed it up, they are supposed to clean it up. And it's important because it has been decades, and that contamination doesn't automatically stay where it is. It has already moved. For example, perchlorate has already been found in about 1/3 of the wells in Simi Valley. That's that component of some rocket fuels. I want to quickly go to one other matter related to the AOCs. So this is the response to comments for that agreement of principle that I just showed you that's incorporated into the AOC, prepared by DTSC. And it has some very interesting points. There were 2 public comment periods. And in the first one, they had over 1,700 interested community members and stakeholders comment. Nearly all expressed excitement about and support for the agreements in principle. Only 14 of the commenters asked questions or expressed reservations. So 98, 99% in the first round of comments, 98, 99% in the second round of comments, strongly supporting these agreements that were then adopted. And then, this is a little complicated, but it is important for you to understand if you hear from people who want to have a lesser standard. Without the AOC, you are supposed to clean up to expected future land use. And that is based, as you see here, one defers to local government's land use plans and zoning decisions. This land is zoned agricultural. It is zoned rural residential. And even without the agreement on consent, even without a specific law that was passed called SB 990 that's been challenged by Boeing, the existing requirements are to clean up to the existing land use requirements in the zoning and in the general plan. And it is, general plan permits agriculture and it is zoned ag. And the lands around it are ag. And that is the most protective standard. So DTSC says that because of the existing requirements and the high background for cesium, strontium, arsenic, and dioxin as 4 examples, they would have to clean up the background anyway if they just used the normal standards that are required. And that's why what DOE offered was so brilliant. It said, let's not hassle about the risk levels, let's not hassle about these limits. If we find it, we'll clean it up. Because they knew at the end of the day, the background levels were the same as the cleanup levels would end up being. It became simple. The money would go into cleanup, not into paper. And that's our problem, is that most of this has been paperwork rather than actually cleaning up. And here's the key point that they make. There's a statement in here which says that even in the absence of SB 990, the law that's been challenged by Boeing, and even in the absence of the AOC, they would still have to clean up the background. So let me end with a couple of photos, and then we're going to hear from the agencies, not only their progress in complying with the AOCs, but I hope they'll be candid about their intentions as to whether they are committed to living up to these legally binding agreements. Because some people in the community have gotten nervous that there is going to be a breakout from the agreements, and we may not ever get a cleanup at all. So that's Area 4. And that is what? Right. See? And the young'un?
Yes.
We call it calf.
Oh, they call them young'uns. And that's just a couple years ago. This one is from 2007. And this is actually on the field lab property. And another one. See the field lab with the cow grazing on it? And this last one, you can't make out the photo. It's a much older one from the government report. But you'll see from the label that it says that the photo shows a herd of cows observed by the former sodium burn pit. So you just don't want to be drinking milk or eating meat or growing oranges or any of those things from a site that's contaminated or from nearby areas with a site contamination. That's why the law says you have to use current zoning. Current zoning is agricultural. Even if there was no SB 990 around the law on Santa Susana, even if there was no AOC, we'd still end up having to clean up the background. But there is an agreement. It's legally binding. And it's, we need to see whether it in fact is going to be carried out. Last point. You may have heard that Boeing has filed a lawsuit to try to overturn the state's cleanup law that deals just with Santa Susana. This is from the amicus brief by the federal government, and it says, 2 federal agencies that have carried out activities in Santa Susana have entered into administrative orders on consent that govern the cleanup of soils at the site. This court's ruling on the constitutionality of the challenge statute, SB 990, will not affect the cleanup efforts and commitments of the federal agencies pursuant to those AOCs. And it goes on to say that in the view of the United States, invalidation of SB 990 would not affect the enforceability of the AOCs, and as noted above, the federal agencies are committed to the cleanup described therein. So with that, I think we'll turn it over to hear from the agencies if indeed that commitment remains. Thank you.